And hello, everybody. You're very welcome to a new episode of Redefining CyberSecurity on ITSPmagazine. I'm your host, Sean Martin, of course, where, as you know, if you listen to the show, I get to talk to all kinds of cool people about lots of cool things, security and privacy related. And today's no different. I have a really cool guest on, and the topic, I think, is going to tweak our minds just a little bit because it's going to force us to think about stuff differently. And I'm thrilled to have JC Heinbockel on to talk about IP and privacy and perhaps some deepfakes and impersonations and who has rights to what and who has legal control over things and legal recourse if they're being abused or whatever online or however. I guess it doesn't have to be online even. But JC, it's thrilled to connect with you, and a shout out to Puya for making that connection. Thanks for reminding me.
You're very welcome.
So much
delighted
going on
to be here.
But thrilled. So and we're gonna just the idea of something being called the ELVIS Act coming out of Tennessee. That was intriguing all on itself. So, but anyway, here we are. We're gonna have some fun today. Tell us a little bit about who you are, what you up to. I know you do some legal work, obviously some IP stuff, working with Puya, but who's JC?
Sure. Well, you started with the career, so I guess that's where I'll start. I'm a lawyer by trade.
Very American thing to do, isn't it?
Isn't it?
Who are you? And that means where do you work? What are you?
Well, I'm an intellectual property lawyer. I focus on brand protection typically. I came to IP protection because before I went to law school, I was myself an amateur artist of sorts. I played in a rock band while I lived overseas in China. And that was a fun, exciting time to be in a creative community. There were all sorts of people doing fun, interesting things. You could start a business or a project at the drop of a hat. And I was around all these creative people, and I was doing creative things, and I was making no money, and was trying to think of, where does my career go from there, and applying my skills and my interests. And that's how I got into intellectual property and intellectual property law. And it's a fun journey. It's a really exciting field, a lot of fast-moving developments, and you get to learn about so many cool businesses and brands and projects and inventions and fun laws like the ELVIS Act that's brought us together.
That's right. Yeah. No, that's Scooby-Doo or Yogi there. Anyway, that was a very bad impersonation. I'll stop right there. Let's paint a big picture first, because one of the things we wanted to talk about is kind of the rights of publicity and how those interact with intellectual property rights. And the first thing that comes to mind for me there is celebrity and paparazzi and the never-ending battle there, and you mix in brands and influencers, and I mean we can start to tack on all kinds of layers on this. But because I mean an influencer to celebrity ultimately is a brand. Perhaps they have IP. I saw some post the other day of, maybe it was another one from Puya, funny enough, about Taylor Swift has a lot of patents and things or trademarks or IP on stuff that terms she's created or whatever.
Yes.
Anyway, what's this big picture? Because when I think IP as a security business professional, I immediately go to somebody building some software.
Right.
Because that's my mind. But it seems like it's much, much bigger. So what are some of the things you look at?
Yeah, well, so you're right that intellectual property tends to think of certain discrete categories of things, right? You've got your copyright, which is protection in creative works. You've got patents, which are protections over inventions. And you have trademark law, which is protections around branding, the source of goods and services. The right of publicity is adjacent to all of that, but it really comes out of kind of more personal privacy rights. It's a patchwork of laws that span across all 50 states where it's a different regime. And it originally kind of comes from this idea of the right of privacy, right? That you have your inherent right to protect your own image and likeness from misuse. The right of publicity spins off of that to commercial uses. And it differs in every state, right? Not everyone has a right of publicity, as it were, in every state, right?
Can you describe right of what? Shall I say it? The legal description of right of publicity.
Well, so
it could be this long, so maybe an abridged version.
What I was trying to get to is that the right of publicity is essentially the right to exploit your likeness for commercial purposes, right? Or in another way, the right to exclude others from using your likeness for commercial purposes. Likeness is maybe an ambiguous term, but that's almost intentional. The likeness is typically going to be a person's image, right? A photograph of you or moving image of you. It might be your name. It might be, your signature or something like that. In some places, your voice is included. And in fact, the ELVIS Act is a statute that is meant to explicitly include voices within the scope of likenesses, at least in the state of Tennessee. But so that's really what we're talking about. It's this right to use and to prevent others from using you for commercial purposes, whether that's advertising, mostly advertising, but other sorts of promotion or commercial ideas.
So would a scenario be I'm sitting in this really cool, swanky place drinking a name brand beverage. Mm-hmm. And I post that on Instagram or something. And would it be that I have the right to publicity, but only for myself, that could prevent the name brand of that owns that Coca-Cola, or I just said it anyway, the name brand of the drink, preventing them from using my likeness in that image to promote their...
That's a big part of the idea. Yeah, we actually see a lot of cases right now, more so actually involving copyrights, but where brands find pictures of celebrities wearing their clothes, mm-hmm. taken by paparazzi, and they say, "Oh, look at this! So and so is wearing our famous sweatshirt. Check it out." And then there's a lawsuit incoming, right? The paparazzi has a copyright. They took the photo, they own that, and they have the right to prevent other people from reproducing it. But the celebrity might not want to be, an endorser of that brand. And so they might be able to say, "Hey, you don't have the right to use me in a post promoting the sale of this sweatshirt just because I'm wearing it." So that's publicity rights. We've seen it a lot in advertising contexts, more formally than social media, right? One of the kind of foundational cases that I think almost every law student reads in just their general property case, even if they're not studying intellectual property, was a case involving Vanna White, where there was a brand that used a robot that kind of looked and acted like Vanna White, turning the letters in Wheel of Fortune. And she said, "Well, hey, wait a second. Like, there's value in that. I sign a lot of contracts and do a lot of ads. You're not paying me. You're violating my likeness, my persona." That's kind of how it all starts.
Interesting. And I get to dabble in some stuff that takes me to premieres and openings and red carpets and things like that, where plenty of people are standing next to a step and repeat with tons of brands.
Right. Yeah, it goes both ways, I guess. The brand has trademark rights, right, of someone creating an association with them, just like someone with a commercially valuable image has a right to prevent someone else from creating an association with them that they don't want.
All right. So earlier today, and I mentioned this before we started recording, we were talking to some folks out of the European Union about data privacy and AI Act. And one of the things that was triggered for me during the conversation was the idea of, so I think what we just described is a real person wearing a real brand,
yes,
used by a real brand to benefit from that. But the thought that I had was kind of this misinformation and deepfakes where brands or others are misrepresenting people and the use of their brand, maybe, I don't know, manipulating images, creating images, voices, whatever, creating ads. I don't know. What are you seeing in that regard?
There's a lot of proliferation around that right now. And that's one of the reasons why the state of Tennessee ultimately decided to pass this ELVIS Act, which we keep talking about. I guess I should mention, Tennessee has had Tennessee has had laws on the books for the right of publicity for at this point almost exactly 40 years, and part of that came from the need to protect the Elvis Presley estate, and extending postmortem rights to celebrity likenesses. But the general idea was this was a law on the books, as opposed to the type that is just kind of the court looking at general principles of law and creating a scope of rights that way. And the idea was that it protected the estate from the unauthorized use of a person's likeness for commercial purposes, and in particular for advertising. So you couldn't say, oh, this was Elvis's favorite peanut butter and bacon sandwich right here, right? That's against the law. The ELVIS Act is now an extension of that, is to essentially prevent a lot broader use of likeness, and in particular voice. And that's a response to deepfakes. We've seen a lot of action on deepfakes from a personal privacy standpoint already. A lot of states have taken action because of the potential for deepfakes to create sexually explicit content involving people who don't want to have their images used for that, right? For obvious reasons, without their consent. This is the first law here in Tennessee now that is applying the similar deepfake principles to commercial purposes. But that's also a response to the fact that we're already seeing it happening. Over the last year, we've seen a number of deepfake ads, some of them which have led to lawsuits and some of which haven't. But I think we've seen, for example, Clint Eastwood in ads for CBD gummies, which he took no part in. There was a story about Tom Hanks.
He said he remembers.
Right. There was a story where Tom Hanks had to disclaim on social media his involvement because there was a dentist's office that I think was using deepfake Tom Hanks in ads for their practice. It's becoming a bigger problem, and it's one thing for it in a commercial context, right? People have valuable images that they want to use and license and endorse things with. But you're also seeing it on the flip side in more troublesome contexts, right? And probably we'll see more of it over the next 6 months in the political realm, because these have gotten so convincing. And so states are really concerned about this, and there's no national law really that prohibits it beyond general principles of unfair competition in advertising, at least in the commercial space. And so the federal government, and that's partly constitutionally to get really in the weeds, but they've left it up to the states to kind of create this patchwork and regulate their own jurisdictions on this type of stuff.
There's so much here.
I think, I left you with a lot.
Because the other thing I'm thinking is, I don't know how this compares to individuals. I'm thinking like the SAG-AFTRA stuff from
right.
Where there's an agreement, but if they happen to be in the state of I guess the agreement ended up being that they couldn't use the likeness anyway. But
right,
if the agreement says we grant you the use of our likeness, but you're operating out of Tennessee, there might be some conflict there, perhaps. I don't know.
I think probably not, right? Because the key is unauthorized use of a person's image. And so, I'm not familiar with the details of the SAG agreement, but I guess the general idea is that if there's consent to using it, right? If you're consenting to let the studio scan your body to create duplications for different purposes, then that is outside the scope of it, right? You've said that's okay. Now, if they then went ahead maybe and sold it to, a potato chip company to use in a commercial, maybe that was outside the scope of what was permitted in that agreement, and that could be a problem. So there's nuance there.
Okay. So bear with me now, because my audience is generally, very interested in privacy, of course, and very business oriented. So business leaders, security leaders, privacy leaders. And so what I want to do is maybe, because this is a great overview of kind of what's going on there. What I want to do is maybe speak to them a little bit in terms of some of the things they might have happening in the organization that maybe they should be paying attention to. And of course, they have legal counterparts there that hopefully, if they're listening to this, they're bringing them into the conversation. I'm just thinking, so clearly marketing and advertising, right? The use of these technologies could potentially put the company at risk. But I'm thinking in terms of just, so those are pretty open and overt and obvious, perhaps. But I'm thinking more now of things like customer support chatbots, or I don't know, things like Meta that may have services that use information and data to generate something else. I don't know. I'm just wondering what are some signs that perhaps an organization might be close to stepping over the lines in some of their business operations that could put them in jeopardy of one or more of these laws, ELVIS or others?
Sure. Well, there's the obvious one, since we started talking about it, is use of other people's likenesses, right? That's a big pitfall. A lot of brands have been wanting to use celebrity likenesses or public figures likenesses in advertising before AI came about and they could manipulate it, right? We counsel clients all the time on how to use images that include easily recognizable faces, and it's going to again be a kind of a complicated question, but the general idea is that you have to be mindful of where you're going to be using those images and whose images they are. And all of that affects what rights those people might have. Are they living or are they deceased? Were they people who use their images to endorse products, or were they simply, politicians? What are you suggesting something that's not true about either those people or the connection between them and your business? Those are all big questions that you're going to need to ask yourself. We also see some other things come up. AI, and especially generative AI, we see its potential to create really unique images, not just involving people, but we have to remember that those AI images are trained on other works. And there have been a lot of lawsuits about the way that AI companies are training their LLMs and other generative AI models, and the output of that too. And I think for most businesses, that's kind of an interesting question to watch. But we actually have seen some cases of where, like, for example, a photo agency's watermark didn't get erased when it was, integrated into a larger picture, right? And so you're looking at this image and you're going, oh, it's really cool, and it's from Getty, and so you're right. So that could create issues, right? You have to really be careful about what output you're using if you're going to use that for advertising or for any other purposes. And then, of course, there's a really fundamental question too about whether or not works that are created by AI are capable of protection. And this is a potentially really expensive question. If you are someone or in a business where ideas are your assets or your capital, and you're using AI as part of a process to create something new that you want to patent, well, certain types of AI generation actually might invalidate a patent grant that you might have, because the patent law really only gives patent rights to human inventors. That doesn't mean you can't use AI to create something or to invent something, but the Patent Office is starting to require disclosures, both here and in the EU, actually, about how you used AI, if at all, to create something or to invent something. Likewise, the Copyright Office won't register a copyright if the work was basically, substantially an AI work, because you need human authorship to create copyright under US law. There's a case right now at the appellate court where the Copyright Office had denied someone a copyright registration because he put in some prompts and created an image. And they said, no, this was AI. This is not a human author. And he's trying to say, no, this is still capable of protection. So there's open questions there, but I think there's a lot of value that people could be creating or losing if they're not paying attention to those types of questions.
Yeah, I love it. And we can go, I naturally want to go down to the creating code and using large language models to help with that and whatnot. But let's stay true to the core topic. How about, what was the other thing I was thinking about? The concept of likeness. Mm-hmm. You said it was vague purposefully. I think we've talked about in the context of a physical being, right? And a face primarily. We talked about it in terms of voice. But I could see that those two things kind of just getting washed away, and there's much, much more to a likeness that could come as technology continues to advance. And I guess what I'm leading to is the data that makes our digital versions of ourselves really becoming our likeness in a digital world. So maybe not just the voice, but the words we use, our gestures, medications we take, where we go on vacation, who our friends are, these shape us as humans, become our likeness, and the data from those experiences, the more we capture them on our phones and watches and rings and other people's phones and watches and rings, catching our stuff on their own devices. I guess my point is the likeness seems to become much bigger. And I don't know, maybe I'm a little out there, but I could see a movie script where my likeness and my story is created in that movie, based on information. I could see that's me. My family could see that it's me being represented in that movie. Maybe others don't, who don't know me, but I don't know. It's an out there kind of thing. I guess likeness, the definition of it, and where does that lead us?
That's a really interesting question. And in the lead up to this conversation, I was thinking a lot about an article that from the mid 90s called Cyber Law and the Law of the Horse. And it was a speech given by a federal appellate judge. And the premise of this article was that we were starting to see in the 90s, and we still do today, a proliferation of these kind of subject matter courses. Cyber law was the big hot one at the time. And this judge was saying that, it's fun that we have cyber law classes, but you don't see classes about the law of the horse, right? But there's so much law that's built out of, horses kicking people and causing accidents, people negligently riding horses, the sale and the license of horses. And at the end of the day, what we want to always remember is that the bedrock principles of the law adapt themselves really well to new technology. And so the idea is that when you're thinking about new technology, right, and the way that AI might affect our personal rights and the way that they're used whether it's the studio making a movie out of your life without you knowing, or something like that. These general principles of privacy rights are in a lot of ways going to be just as applicable, even if there's not a specific law that says you can't do that. And I think we should be mindful of that. One of the things that's interesting about a lot of these, the contrast between publicity rights and privacy rights, is that publicity rights are really meant for people who have proven that their likeness has a value, right? Those are movie stars, athletes, and other people who endorse things and who would sell their image. Whereas most of us in most places don't really have strong publicity rights, because you and I are not, signing contracts to get photographed holding, a cool new invention or a cool guitar or something like that, wearing the neatest outfit. But we do still have protection, and states are trying to address that with a lot of these new deepfake laws that are geared towards preventing sexual exploitation, but they might have greater applicability. And so I think you've raised a really interesting hypothetical, and I don't think we've caught up to that yet. But I think that, as I said, those general principles, right? The idea that, an accident caused by a car is an accident caused by a horse, right? As technology evolves, these general principles, they still stand for the same things.
All right, I'm gonna continue to pretend I'm on gummies, like what was it, Harrison Ford?
Like Clint Eastwood.
Clint Eastwood, there we go. So here's another one, just for fun. Let's have some fun with this. So I, as an individual, clearly have zero value as a public figure. 10,000 of us connected together as customers of an organization to create a common likeness that the company's then exploiting to make money. So presumably for advertising it. So dang advertisers, they cause all the trouble, and the pornographers. But anyway, so I'm just wondering, again, in the context or the definition of likeness, I think the ELVIS Act is an individual, right?
Yes.
And probably the others are as well. But is there an idea, or should there be an idea, that a collective of attributes that create a likeness that's being exploited? I'm just thinking class action suit, right?
Yeah, well, when you say a collective likeness, are you thinking of almost like an avatar, like an image that represents the full, the full community of listeners, or are you thinking of almost more like a logo, a brand?
So I'm thinking it's a virtual representation, whether it takes form of an avatar or some human-like thing, I don't know. But there's a collection of information that becomes valuable, driven by my data and others.
Yeah.
That's then being exploited. And I don't want to be part of it.
Right. Well, that gets into sort of questions of, the typical types of data use questions that we have, right? And the questions, or rather the things that laws like the GDPR and California's data protection laws, and there's a number of other states that have them now, are trying to solve, I suppose, right? What kind of data can you use, and in what contexts, and how can you collect it? And again, in the U.S., that's still a pretty open question to some extent, right? Each state is working through things while the federal government kind of lets everyone go ahead and sees what works. So I think that's where that would come through if I had to put an answer to that question. But yeah, it's an interesting question.
So we're thinking about it, just not maybe through my weird lens at the moment.
Yeah, to me that doesn't sound like a likeness question per se. I mean, I get the idea that you're like a community can have common attributes, but I suppose, if there's a way that community could have some sort of a legal personage that could then represent you in court or something like that, right? And It's a tricky question.
Yeah. All right, so I'll get off the gummies now. So let's bring the. Thanks for entertaining.
It's a really interesting question. I mean, that's yeah.
I don't know if I entertain anybody else, but anyway, I'm thrilled with myself. But so back to the business end of things here. So people are litigious, even if they have no right to be. So I guess is the companies operating out of Tennessee or bound to the ELVIS Act, or is it?
It's anyone who's engaging in that content or behavior within the state of Tennessee, right? So you don't have to be a Tennessee company. If I here in New York, make an Elvis deepfake and I, start buying billboards in Memphis, right? Or I'm start, putting up, making robocalls using his voice or anyone's voice, right? That's that's conduct that's exactly. That's conduct that's entering into and targeting Tennessee. That's going to be the problem, right? It doesn't matter where I'm doing it from.
Got it. Okay. All right. I'm trying to think of what some of the things organizations should be kind of preparing themselves for here. I think the obvious one is using Gen AI to create stuff that they don't know the source of it. And
well, the big thing for companies is that if you don't have a generative AI policy, it's time to start thinking about it, right? Put guardrails in place and guidelines in place for your employees on how they can use AI, right? And not just for what they're generating, but because a lot of times, if you're contributing information to an LLM, into a AI platform in order to generate something for you, that platform is going to then reuse your inputs to learn. And so are you putting in confidential information that is maybe going to lose some of that confidentiality by, creating prompts for an AI platform? That's another thing that people really have to start thinking about if you're running a business, because, those types of trade secret issues get complicated really quick. So how are you protecting information that you're putting in? What is coming out too? It's not just, is it going to be a violation of someone's trademark or copyright or personality, right? But all of those hallucinations that we hear about, right? We've seen it in the legal profession with people using AI to generate court filings only to find out that the cases cited in there were completely made up. Well, how does that affect you if you're writing a white paper and you're citing articles that are made up or, something like that? So there are a lot of new AI platforms that are targeted towards certain industries to avoid those types of hallucinations, right? They're using closed universes. So maybe you have to ensure that your employees are using the appropriate AI platform instead of just letting them do whatever they want. It really covers so many different areas of the law. You could go on for days and days and days about different risks.
And I'm going to go back on the gummies. I'm sorry. No, one more thing as I think about this, because let's say you are an agency representing personalities, figures of in the public that have value, and you're using AI to use their likeness to create new stuff. Because I don't want to make. I could easily go back to the IP.
Yeah.
Maybe we have another one on that, but because I had a conversation with somebody talking about a digital signing service where people were submitting contracts with detailed data that they didn't want in there, and signing their trademark documents and their patent documents, right? So, right. And this company using all that content to train whatever their own systems for, right? Presumably in a closed system, but potentially connected outside. So I guess that leads me, so we'll leave that there, but in terms of representing public figures, and I guess, does the law extend to a company in that way? So they're kind of the middle person, the middle entity. So I don't know what I'm trying to say here, but I guess you represent brands, you're using technology, AI, and specifically to help you manage those brands.
Yeah.
And something happens that takes you into ELVIS Act territory that you didn't expect.
Yeah. So if you're, I think you're saying like a marketing agency or an ad agency, yeah, you could absolutely be just as liable as your client, depending on your agreements too, right? What types of indemnity provisions and waivers and releases you have. But generally speaking, if you're the agency that's involved in that, your client asks you to do something, you create it and you give it to them and then they use it, you could both absolutely be liable. So at all levels, you want to really be careful and really be thinking about what you're creating, what rights and consents you have or don't have. And what are you trying to really achieve? Yeah.
That's a great point. Well, I think we'll use that to close it. What is the outcome, and where does the outcome lead you?
Right.
And I think to your point, having AI policy and understanding what you're trying to achieve. If you don't have that in view, in plan, in motion, you're probably leaving yourself exposed somewhere.
Yeah.
No. All right. Well, JC, I mean, I took you on a journey you probably didn't expect to go on today.
It was really a lot of fun, Sean. This was a really fun conversation.
I was thinking, it's been a long day, and I'm thinking out there a little bit, but I appreciate you going on the ride.
That's all right. I'm going to be up all night thinking about
that's right.
Collective likenesses and
collective likeness. There you go. Yeah, and for my audience, obviously, I'm most often talking about operationalizing security controls. So this is going to be a little wacky for them as well. But I think there's something here. I think ultimately it comes down to technology and how technology is being used in the business and understanding how it's used correctly, ethically, legally, all that stuff. And if you haven't thought about it, shame on you. If you don't have a policy in place, you have time to do that now. And sadly, beyond that, it becomes following all the laws. you have to monitor from a legal perspective. But if you do the first two, be aware and have a plan, you're in much better shape for following and adhering to the laws.
It gets a lot easier to follow the law if you plan in advance.
Absolutely. And hopefully the law's tapping into the technologists and the security and privacy folks, so they get set in a way that they can be followed.
Yeah, I think so. There's a lot of people, a lot smarter than I am, certainly, who are thinking deeply about these legal questions and are shaping the law. And it'll be really exciting to see how this continues to progress over the next, even 6 months. But beyond that, I don't think this is technology that's going away.
No, definitely not. Definitely not. Well, JC, it was an absolute pleasure meeting you, and good to have some fun with you today. And I'm certain we got people to think, and hopefully there's a few nuggets in here as well that will give them something to actually chew on as they think. So thank you so much for that. And of course, I'll put a link to the article for ELVIS Act and your profile. Multiple people can come to you with their collective likeness and have to chat with you. How's that?
We're happy to help. Yeah, we can blaze new trails here. So it was a delight, Sean. Thank you so much.
Right on. All right, thanks everybody. Stay tuned for more on redefining cybersecurity and beyond, obviously. And catch you on the next episode. Thanks everybody.